Hey, everybody, fellow Toolboxers. Welcome to episode 341 of the Immigration Lawyers Toolbox. One of our fan favorites, our monthly guest, Kevin A. Gregg, is here to talk about federal court updates in August. This is always one of the most popular monthly episodes. I'm really happy, and I enjoy learning about stuff, too, that I never deal with any time. So it's good for me personally as well. Before we get started, I want to let you all know that our marriage green card course is happening, the 18-hour plus course with mentorships, breaking down CFR, the INA, affidavit support based on the rules, how you deal with the domicile issues, how you challenge in that. The best thing out there really holds your hand through the marriage immigration, family immigration process, from consular processing to adjustment, the consultation, what to ask, who to talk with when to close the deal, the contract, how it looks, what inadmissibility question asks, all that kind of stuff. If you want to get it, email me at info@immigrationlawyerstoolbox.com. On our website, we have great reviews of people who've taken the course, and it's been a real passion project. We also, for free, for lawyers in general, have a community called Circle.so. It's a website, but it's for the Immigration Toolbox, which have regular CLEs coming out. We have some really good ones on abandonment of green card, how to avoid that. If someone's been out for 10 years, we have one about 212D waivers. It's just really good because most lawyers don't know that even exists. And a lot more stuff. Might get Kevin A. Gregg on one of these CLEs too. I want to let it get. So, having said all that, there's probably other stuff to talk about, but let's just jump into it. Anything mentioned here is not intended for individual legal guidance. Consult with an attorney, but y'all know that. All right, let's get it started. Hey, Kevin, how are you?
Talk to my agent about getting me on. It's not easy. I require at least $1 million to just appear anywhere. That's just my face, $1 million. Also, I'm curious, fan favorite. Who is this fan?
Oh, this the numbers. The numbers always
I want to know the one
the
fan. I want to
yeah.
know the one fan for whom I'm their favorite.
It's Legion. This is all of them pretty much.
Um,
So good to see you. Your podcast, Immigration Review, is doing great, and you're keeping it up, especially in recent times. How busy you are. Good job at that. How's traveling going on with everything?
Not so much yet, but I'm about to travel. There's merits hearings coming up this month and next month. Thanks for asking. I said no to a couple of speaking events because, as you know, my wife and I welcomed our first child recently.
God bless.
Thank you. So listeners of my podcast might start hearing some crying in the background soon. Episode 228 posted on Monday, John. And let me get this. So, like everything I do, like all these cases, I can't just do it off the cuff. And when I go off script, like it's a horrible edit for me because I mess up 6 times. So, like everything
Yeah.
I write to it mostly is written. And the Word document for 227 episodes, it gotten so big. There were over 1 million words. It got
Wow.
so big that I had to start a second Word document for the podcast. So that's how the podcast is going. So much that it has made Microsoft Word crash numerous times, such that we're on version
Yeah,
two,
let's say
volume
definitely
two.
that long. The load time alone is like every time I open it, it probably takes a little bit to get stuff
Right,
together.
I shared it on like the cloud rather than our firm's shared drive because for that reason too. But yeah, even that it killed the cloud. That's how the podcast is going.
So much for the cloud.
um,
Well, good to see you. So you busy times, the baby. I don't know how you could do a hardcore podcast like yours, but
we'll
you're a soldier. You do it, I guess.
we'll see. It's only been 1 week so far. Liz filled in. My one of the colleagues at my law firm filled in for a week that we actually had the child. And there was only one decision, which I mean, I was happy for Liz, but then the next week there were 8. Like, what the hell?
Yeah.
And so I've actually only done 1 week with a child. We'll see what happens.
Actually, speaking of which, there was a case about an adoption and them calling the citizenship into question.
Oh
Are we going to
yeah,
discuss that? You know what I'm talking about?
oh yeah. There's that. There was actually the adoption one. They're all last week. There was like 3 citizenship cases last week. The adoption one was is that the ninth? No, that was the Third Circuit, I think.
I know
Maybe
because I've
not.
had cases where they were adopted and the
It
paperwork
was
doesn't look too good.
that was
Like,
so
"Eh,
rough. Yeah, I'm not gonna. I won't. I mean, that's a September case, so we're not doing that on the
okay,
August rundown. But or at least that was for the September week. But in any event, I'm not. I wouldn't do that one on your show because it's a loss for the non-citizen. But that individual, this is not prepared. Just remembering from last week, they INS really messed. It was like 1975. The guy gets adopted. He's 17 and like a half, and he sits for his interview. He does everything right. Like who does that?
yeah,
And he gets his parents do the certificate of citizenship. He sits for it after he turns 18, so he wouldn't be eligible for one sort of derivative citizenship because he was already 18, but
Yeah.
also the INS officer like also said that the adopted parents became citizens like right then in 91 or whenever it was when they became citizens in 75. And so like the old provision that gave the adoptee citizenship if their adopted parents became citizens like when they were 18, like the whole thing was messed up, and he didn't lie at all. Like INS just
Yeah.
totally messed up, but no one told the guy until he's in prison for dealing quite a bit of cocaine, if I'm
Yeah.
not mistaken. And then like USCIS says, "Oh, by the way, we don't think you're a citizen." Like, can you imagine getting that letter? And
Oh,
like,
man.
I mean, look, don't deal 5 kilos of cocaine, but also in between his cocaine actions and 1975 or whenever it was, like he would have naturalized. You know what I mean? Like
Yeah.
it's so unfair. And I think it's the Third Circuit. They say estoppel, and this is a great segue into what I'm about to talk about, by the way. But the Third Circuit says estoppel doesn't. You can get estoppel in immigration court. You can stop the U.S. government from doing something with immigration stuff, but not with citizenship. Which is real. I mean, I get it, and the Supreme Court case law is what it is. But like, it's so harsh. And no, I don't know what was argued, but like, I've done these, haven't won, but like
Yeah.
you should be stopped. If nothing else, you should permit this individual to apply for naturalization as if the conviction didn't exist under a program that existed at the time. Like we had one with like a
Unquote, or
Haitian
something.
individual who was wrongly convicted, and he could have gotten HARIFA and all these other things had he not been wrongfully convicted, for example. And the guy got a green card legitimately. He doesn't apply for naturalization for 30 years because he thinks he's a citizen. There must be a remedy. The Third Circuit says not every wrong has a right, which really, it might have been the Fifth Circuit. I can't even remember at this point who was,
Yeah.
there was
That's
a lot of
yeah.
them. But yeah, that's a rough case. He was deported in the interim.
Damn. That's a shock. I mean, to go to another country and not even like know anything about, and
Crazy. That's not even a case we
yeah.
were going to talk about this week, but it's a good segue into United States v. Munoz out of the 11th Circuit from August 7th. Also about estoppel. This one's about denaturalization, which is you get a lot more protections than in a lawsuit for a certificate of citizenship. If the U.S. government wants to denats you, like they have the burden and blah 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 blah. And it's always these conspiracy cases that get these guys. There's good case law, including the 11th Circuit, that if you are convicted, if you do something as an LPR, but you're convicted after you become a citizen, that can't be an aggravated felony, even if you get denaturalized, because the aggravated felony provision only applies to aliens, and the conviction doesn't occur when you're an alien. Good case law. But these denats thing, yeah, that's great. But these denats cases, they so often come in the conspiracy context where, like, the conspiracy begins in '05, the guy naturalizes in '07, he doesn't get indicted until '09, and then he pleads to some conspiracy saying, yeah, from '05 until '09 I was dealing all these drugs. But that means that
Yeah.
when he filled out his N-400 and went to his oath ceremony, he just he lied, right, when he said I
Yeah.
haven't engaged in criminal conduct, blah 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 blah, because he was in a conspiracy. He just admitted that in a criminal proceeding. And so that is so often the basis used to try to denounce these people. And I mean, that's what happened here. Maybe the years are a bit off. So cocaine and marijuana trafficking, blah 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 blah. And maybe I don't know. Maybe he did it. Maybe he didn't. But he's going to get another shot in district court because the district court judge said no. He is equitably estopped from claiming that he didn't commit this drug activity before he naturalized, based on his conviction, which had dates before he naturalized in the conspiracy. Right. The 11th
Hmm.
Circuit said no. Equitable estoppel doesn't apply to dates in a conspiracy because the dates that a conspiracy occurred are never elements of the offense. It's never something, I guess, that the prosecution needs to prove.
Mm.
So that means that it wasn't. And then the third element for equitable estoppel, which we're usually using as non-citizens counsel, is the issue that you want to stop must have been critical and necessary in the prior proceedings. And here's the 11th Circuit saying, no, the date of a conspiracy is not critical and necessary. So equitable estoppel doesn't apply. That's a pretty big deal. It means, at least in the DNATS context, and I don't know, maybe in removal proceedings, that the prosecutor or DHS can't just rely on the dates in a conspiracy thing that was pled to, because those were actually superfluous. They weren't necessary. It's interesting. Then the 11th Circuit talks about the doctrine of judicial estoppel, which I had never even heard of, which wants to prevent, perversion of the judicial process. And here they said that wasn't the case because Mr. Munoz actually, it wasn't necessary, these dates. They didn't affect anything. They didn't get him a lighter sentence. It's complicated stuff.
Mhm.
Estoppel always is. But it's an interesting case from a circuit that's not always non-citizen friendly about estoppel and denaturalization. Now, don't get me wrong. It's going to go back on remand. The government's going to present the conspiracy conviction and say, Judge, he was ineligible at the time. He pled to this. And this guy, Mr. Munoz, is probably going to have to go on the stand, and he better be damn credible. Because he lied somewhere, right? He's either lying in court right
Yeah.
now, or he, wasn't accurate during the criminal case. So uphill battle, but also it's the government's burden. I don't know. Very interesting case, United States v. Munoz. All about estoppel. Um,
All I remember is stop was in contracts class. I remember it was the stop loss as far as I remember about
well, it's
that.
important.
Torts? No, torts
It can
didn't
be
have it.
important in
Crim and
immigration. It's most important, I've found, in naturalization, where like USCIS is coming. You're trying to naturalize. You got asylum or you got a green card in immigration court, and USCIS is trying to say, okay, fair enough, but we think that you are ineligible for naturalization for this reason, and you say, well, that issue was already litigated in immigration court, or that issue could have been litigated. You see it in the terrorism stuff a lot now.
hmm
Old cases got asylum. Material support of terrorism wasn't even brought up, and now 20 years later, they're saying actually material support of terrorism, and the argument is, well, that was already litigated because if I had supported terrorism, I could have never got asylum in immigration court. But it's a complicated argument. This is using estoppel in the reverse. So estoppel, I
hmm
don't know. Always taking a look at estoppel cases for that reason,
Yeah.
and the small amount of
Very.
us who do denaturalization.
How often do you get involved with denaturalization?
I've been with the Kurzban law firm for over 7 years. We've had a couple. Um, Usually,
When Trump created the denaturalization task
yeah.
force, that never really itself went into effect, right? It was
No,
just
I think
basically
all
that.
these DNATS cases we see are from that.
Oh, okay.
I mean, don't get me wrong. I didn't start doing the podcast until May of 2020, but I didn't start seeing these DNATS cases until a couple years after the Trump denaturalization task force. There's a trickle of them. It does seem like oil is picking the lowest of hanging fruit to do it because it's their burden. But I mean,
Yeah.
wouldn't you? And that lowest of hanging fruit is the conspiracy cases where these people have to admit that they committed this conduct before they naturalize and they get the conviction.
Yeah.
But here's the 11th Circuit saying not so fast. So it's important in that sense because I mean, I have no reason to believe, but I wouldn't be surprised if at least 50%, if not more, of denaturalization cases involve conspiracies. So it's
Okay.
interesting.
What we got next?
Right. So if your brain isn't fried enough. Um, I got a few. They're all interested and heavy. Then the Ninth Circuit Bent v. Garland at August 15th. It's a great case. Like the entire immigration world was on this case in some way. Carrie Hong argued it, who's brilliant, with the Florence Immigrant and Refugee Rights Project. Even Ira had his name on this, and Amicus. I don't even know if he knew it was on. I didn't know he was involved. But at base, this is about California Penal Code Section 1473.7A1. It's a statute that permits the vacating of criminal convictions in California. And here's the Ninth Circuit, to me at least, and I messaged Carrie and she agreed, but it's not legal advice. To me, it seems to be the Ninth Circuit saying getting your conviction vacated under 1473.7A1 will be recognized under immigration law that qualifies for matter of Pickering, matter of Thomas and Thompson. That suffices. That's how I read this decision. So that in of itself is a big deal for California immigration people. Here's the statute you can
So
go to because the underlying reasons are solely procedural or substantive defects. In this case, that he was, I think, misadvised or not advised about the immigration consequences, making it a Fifth Amendment violation, blah, 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 blah. And that makes his conviction legally infirm from the get go.
Okay. Just the random stuff in my head. I remember California did pass it to try to fix the immigration issue in regard to these, and then the Supreme Court or some big court said no, you can't do that. But is that maybe I'm thinking about different cases and stuff? But is there kind of carving it out here for procedurally? It's
No,
okay.
no, I think now that was a long time ago. That Ninth Circuit case. I think it's 1473.7A1. I'd have to do some research, but I mean, I believe it is because this is the statute that I believe came into existence in 2017. What the Ninth Circuit says there is that it's not prospective. So that was no, that was different anyway. I'm sorry. That statute made certain convictions misdemeanors less than 1 year, such that
Yeah,
it
that's the one I'm thinking about.
such that it met the petty offense exception of CIMTs. This is different. This is getting rid of your
Okay.
conviction altogether. Another thing California did for non-citizens that's exceptionally helpful. But if it's just for immigration reasons, immigration doesn't want to recognize it. And that's what's also important. You're getting these decisions out of the BIA, including the underlying decision here, but also a precedential one out of the BIA, matter of Azrag, I believe, from a few months ago, where the BIA is really looking into the papers to see, wait a minute, like I know it said this, but what was the real reason? Was the real reason just to be nice
Mm.
to immigrants? Because if so, it's not valid. But to me,
Yeah.
and as I read the Ninth Circuit decision as well, like they could have flat out said to the judge in this case, please grant this because our guy will be deportable if you don't, and we want to be nice to immigrants. And if the judge had issued a decision saying, I vacate this decision under Cal Penal Code Section 1473.7A1, the BIA would have to recognize it. Because I don't think it should matter. I don't think it, and this is an open issue. This is not legal advice, but it shouldn't matter what's in the papers. If, as a matter of law, what the state court judge does is only a
Yeah.
procedural or substantive defect. And here's the Ninth Circuit saying that with this California statute. Don't get me wrong, don't get cute in your papers. But it's a very interesting issue for that. In any event, your papers for something like this will often say wasn't advised of the immigration consequences or was misadvised. That's a Fifth Amendment violation, Padilla v. Kentucky, all that stuff. Or was that Sixth Amendment? I can never remember. Um, in any event, it's an infirm criminal conviction. So remember this in the ninth, Bent v. Garland. Also, with a motion to reopen, you got to show due diligence, and there's some really good language in this decision about what due diligence is. It's not maximal feasible diligence. And here's the Ninth Circuit also saying, by the way, vacature, that in and of itself, might be an extraordinary circumstance that restarts the clock and allows you to file a motion to reopen. So it's just a great decision in general for vacating convictions and getting removal orders based on those convictions reopened in the Ninth Circuit.
Very cool.
Yeah.
So something
Yes.
it comes into place. Yeah, a lot in
Yeah,
California. It's a
these
nice is a big one to get that.
yeah
Yeah.
these decisions are like you got to just mark them and like go back to them for issue spotting because they're very complicated and trying my best to just get to them.
Oh, it just means whoever is going to hire counsel for these, they got to hire a very expensive counsel who spends all their time keeping
Yeah.
track of all this stuff.
Rosa v. Garland out of the First Circuit, August 16th, also very interesting. And I just want to say I have no proof, but like a week and a half after I discussed Rosa, of course, the BIA issued a decision last week distinguishing Rosa, like not even in the First Circuit. They were on top of it. And I like to think maybe it's because they listen to my podcast. Now, I don't know. I have no proof. And of course, they can look at the circuits too, but who knows? They
Yeah.
distinguished Rosa in the exact way that Rosa needs to be distinguished. And this case regards relying on police reports. And a very old.
Well, you are the cliff notes for them, so if they don't feel like reading, they can listen to you, the cliff notes and all the
I'm sure they read it. I just wonder if they, who knows. But of an
yeah,
old decision called Matter of Araguin out of the BIA. This is about relying on police reports in the discretionary determination to grant or deny relief.
yeah,
Relying on police reports where there's no conviction, just police reports. And in Matter of Araguin, the BIA said in so many words that IJs may not give substantial weight to a police report in the absence of a conviction or corroborating evidence of the allegations contained therein. And that's what happened
yeah.
here. This was, I think the guy was accused of rape or something like rape. It was a terrible, terrible thing, like teenagers in high school and whatever. Terrible, no matter terrible if he's telling the truth. Of course, terrible if she's telling the truth. Just this whole thing, and
Yeah.
the case is still pending. Longtime lawful permanent resident, grew up in America. The case is still pending in criminal court, and immigration court pled the fifth, but his attorney said he didn't do it. And the police report, importantly, like it's just allegations.
Yeah.
It doesn't seem like there were many or any witness statements, no other corroborating evidence. And here is the First Circuit saying you can't, even under the BIA precedent, matter of Eric Wynn. So that's the out of First Circuit stuff. But the First Circuit says that it believes this the rule in the Sixth, Seventh, and Fourth Circuit as well, maybe even the Third and the 11th. So important across the board, like can't just rely on an uncorroborated police report. Nor does the fact that the matter ends up getting prosecuted. That's not corroboration. That's
Yeah.
just they decided to prosecute. Now, don't get me wrong. If they decided not to prosecute, I'm going into immigration court and screaming that. So total hypocrite. But the fact of prosecution doesn't itself establish corroboration. Now, just last week, the BIA distinguished this, or maybe 2 weeks, last week, and saying, well, in our case now, the police report had multiple victim statements and other corroboration, so we can rely on this police report, or the IJ can. So be careful. But important case, matter of Eric wins an important case. And then, bad facts make bad law, good
There's
facts make.
there's a there's a boom 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 sound. Is that on your end or is that on my end?
Well, I don't know. I can't hear it, though. How about now?
No, it's coming back. It comes and goes. Are you shaking your leg or something
Oh,
like
you know
that,
what?
or hitting
I'm
the
sorry.
mic?
I'm touching the mic with my. I won't do that anymore. Well, so
Still happening. Yeah. So yeah, you were saying. Sorry, cut you off at
no,
a really
thank you
critical
for.
time.
Believe me, the audio is important. In matter of Eric Wynn, important to know. Uh, this case important to know, and bad facts make bad law, good facts make good law. In this case, the non-citizen, the IJ had denied asylum and granted voluntary departure as a matter of discretion. But then on appeal, he became adjustment eligible, I think, through his mother. So the BIA
Hmm.
remanded for adjustment, and now he's eligible. And now you already have a finding that he warrants relief as a matter of discretion, and it went to a new immigration judge who I can totally feel. I mean, look, discretion's discretion, and in fact, you
Yeah.
should. There's old BIA case law that says actually you should grant adjustment of status as a matter of discretion where eligible. But like if you're the IJ and this comes back to you, I can see thinking, oh well, it's one thing to grant as VD as a matter of discretion, a whole other thing to grant adjustment as a matter of discretion. But now the IJ is kind of bound, but the IJ got around it. But so anyway, all of that gets mushed up to the First Circuit, and they didn't like any of it.
How does adjustment work in court? Because they no longer have status at this time, right? Or
Well,
do
immediate
they?
relative.
Oh, it's because it was a mom through child, so they're probably aged out. Are they still under 21? Oh, you said it was in high school or something like that.
It's a good question. Um,
Because it's kind of embarrassing. I just learned because I don't touch anything removal that if you have an arriving alien who's been paroled in, even if they have a removal order, if they marry a U.S. citizen, they can adjust status with
yeah,
USCIS. And blew my mind. I'm like, oh,
I
that's
think
everyone's. I didn't even know that was a thing. I was like, how did I not know
yeah,
that?
no, it's true. I think they would need a waiver though of the removal order, but USCIS has jurisdiction. I think they do.
So yeah, I messaged you about that actually right when I had the baby. I was like, "Oh, wait, this is a thing! I can't believe it." And then I read like practice about. That's why I want to do a CLE on this topic because I'm like, maybe other people don't know. I'm kind of embarrassed. I'm Mr. Immigration. If you say removal, I just say, "Okay, I'm walls up. Go talk with Kevin." I
Yeah,
don't know what's going on there.
right, right. You have to look at that notice to appear, and like they could, if they charged him as an Iwi instead of arriving alien, then it has jurisdictional significance. It's crazy. Anyway, that's a good question.
Yeah.
Was he a minor? I don't know. Um, I don't know. Well, under 20, I don't think he wasn't over 21 yet. I don't think, right?
Oof. Yeah. I mean, you said the crime happened in high school or
Yeah,
something
I
like
don't
that.
know.
It's probably
I think it
under
was arriving.
21.
I think it was a immediate relative though. So there you go.
Yeah, probably.
Sorry, there's the boom, boom, boom. Hit the mic again because I got it too low. But
Okay.
so very interesting on just police reports. That's straight up removal defense, and not enough time to get into Tista Ruiz de Ajulip v. Garland out of the Sixth Circuit, but just a really good domestic violence type asylum case out of the Sixth Circuit. This whole thing about defining particular social groups with circularity, Here's the Sixth Circuit saying, you know, IJs, even if counsel doesn't do the best job of defining a particular social group, IJs have an independent role to assess the plausibility of the application on the record as a whole. That they can't just rely on the language used. That's a heavy burden on immigration judges. I'm not gonna lie, I don't know what I think about that. Right? You hire attorneys for a reason. Judges are supposed to rely on counsel, but here's the Sixth Circuit saying, if there's a plausible particular social group in that record, IJs kind of got to go hunt for it.
So the IJ has to do the work as a backstop to prevent. Is
It's
that what
more
you're saying?
complicated than that, right? But it would seem that way. And it's even worse, actually. Like, even if they have an attorney and that attorney has maybe presented a not so great particular social group, the IJ has to be like, okay, that's denied. But have you thought about this one? I mean, maybe read it, but it's a good case on domestic violence type claims, particular social groups in this developing area, and I cannot stress enough how particular social group definitions, all of this stuff, crime involving moral turpitude, it's a new age, Loper Bright, Chevron deference. There is no deference to anything anymore. Is the BIA right about particularity, social distinction, and immutability? BIA made that stuff up in decisions over the last 40 years. They're not necessarily right, and now the circuits don't defer to it. So, whole new world.
Have you how have you run into practically in your practice on cases with Chevron deference issues? Like, have you argued
Oh
anything yet?
yeah, we just. I'm first of all, I'm arguing something on petition for review at the 11th Circuit right now, but that hasn't been adjudicated yet. But we just won a motion to dismiss. Uh, we defeated the government's motion to dismiss in a naturalization case, and in part relying on Loper Bright. And in one sentence, the district court judge says, well, I don't have to listen to the government on that. Loper Bright. Like it's there's not I think the judge said something along the lines of I have an independent duty to decide what the statute means. Uh, yeah, it's
Interesting.
incredible and easier to do in a little district court, not little, but in a district court decision without precedential authority. That's relying on a very wonky issue without getting into it. But as I keep saying on these CLEs, like even if you've got a third circuit, you're in the third circuit, you got a third circuit decision saying a particular social group is particular, socially distinct, and immutable. Okay, now you're facing third circuit precedent directly on point. And let's say you don't like social distinction. If you go back, find all the decisions that decision that you're talking about relies on, and if that initial decision relied on Chevron deference to the BIA, you've got grounds to attack it, it would seem to me. Because it doesn't matter to me so much what the circuit said if at the beginning it was all based on Chevron deference, which is now dead. It might require en banc review, who knows, but like be making these arguments, at least at the circuit level.
It's a brave new world. Yeah, I'm also
It's
going to see
crazy.
how next.
It's crazy.
Yeah.
It's crazy. And then there's USCIS with the regulations and Cower Iser deference, if you can even sue in federal court though, because of Patel. But I've probably gone way over my time allocated on John Khosravi's podcast.
No, I'm sure doing good. We got like go another 5 7 minutes or something like
Okay.
that.
But no, we should challenge everything.
Yeah.
You would be looking at how the courts came to their conclusions that you want to get around. The BIA is bound by its old precedent. Chevron deference has nothing to do with the BIA's decisions. But like even last week, the appellate I.J. Clark in concurrence on crimes of child abuse, abandonment, or neglect, the BIA essentially said attempted child abuse crimes are crimes of child abuse, whatever. But
Hmm.
appellate I.J. Clark said this doesn't apply to attempted exploitation, child exploitation, for a variety of reasons. And oh, by the way, we BIA, we better be careful because the Supreme Court took up two decisions in which it would appear that our definitions of crime of child abuse or child endangerment are at issue. And I, appellate I.J. Clark, don't think it's going to survive in this post Chevron world. So we BIA better be more careful and clear about what we do going forward. That's what the IJ said, appellate IJ said in concurrence. So the BIA is aware um, that they don't, that it's already begun. It's already begun. And I've seen it a little bit in the decisions, not so much. It's only been, 2 months since Loper Bright, but it has already begun.
Yeah, I mean, in the business context, there's a bunch of little things here, RFEs or denials for EB1A and stuff that you could challenge and push around on this kind of stuff to be mindful of when you sue them.
Well, yeah, I mean, look,
So it's
there's the decision I wasn't going to talk about. I still won't, but it's Save Jobs USA v. DHS on August 2nd. Uh, it was about whether H4s get to work and DHS's long
mhm.
pending regulations and this anti-immigrant group, Save Jobs USA, you know, essentially tried to get the DC Circuit to go against what they had said a couple of years ago by saying, hey, Loper Bright, new case law, and the DC Circuit, and it's been a while since I read the decision, they said, oh, that's not how stare decisis works. Oh, it wasn't. It was about the major questions doctrine, so it's a bit different than Loper Bright. They're saying you didn't consider the major questions doctrine before, but the DC Circuit said, well, we decided this after West Virginia v. EPA. Either way, these heady, big Supreme Court decisions are getting thrown around in the immigration context, both in employment and in family-based removal defense. Um,
Yeah.
and things are going to start happening.
Yeah. Well, we have a lot of shows to do on those, so it's great content for me as a media
Yeah, I'm
publisher.
never going to stop getting content for the podcast. I'll tell you that much. I'm sure you won't either.
No, no, just you gotta. Thankfully, I have you to read through it because I wouldn't get around to it. I'll mine. So you're a great resources, Kevin Gregg of the Immigration Review podcast. And if you want to hire your firm, obviously, reach out Gregg with two G's, kktplaw.com. I reach out to you and I send clients your way and also get your guidance, and you do consultations and stuff too for other lawyers. So something that your office offers both you and the partners, everybody. But I would imagine the fresh blood is always the best stuff. And I realize you're really not to put down the
Fresh
partners and
blood's the
stuff, but
best blood. Fresh blood's the blood. So vampires everywhere would agree.
with that, well, I guess we'll call it a show. Thanks a lot for coming on again.
Thanks, John.